My Lord, no, it's fine. I think I would need your assistant, Your Lordship. I have 4 sections to address the court about, and I do not want to waffle, and I don't have enough time to do so, to address you on the 4 issues. I have literally 7 minutes. I would like guidance from the court. I had prepared to argue for 45 minutes per agreement. It's going to be very difficult, but I will stick to your 15 minutes, Your Lordship. It's not your fault, it's ours. Your Lordship, there are 4 topics that I thought I should help the court with. One, I'm going to be brief about it because there's no controversy. The first one is the history as it relates to passing off as a common law action. The second one really is passing off itself as a legal concept. What exactly is it? And how does this case fit in it? And then I was going to deal with the abuse of process flowing from there, but I think I won't bore the court with that. My learned friend, I think, dealt with it. But to the extent that I can address the court on these 4, let me start with what I think I can do in the time I have. But there are 2 domains of law we're dealing with. And this difficulty that you see is because we're in the domain of Section 19 rights, which are political rights. And there are consumer rights, or what you would call Section 22 rights. Those are the 2 domains. It's addressed better in the jurisdiction point, but I just thought I should raise that for the court to assist the court. I cannot take you far, but I'm going to take your lordship to the authority that says, when we get to passing off, that says you cannot, because of the difficulty you've seen my 3 learned friends debating, not knowing where they are about which battlefield are we in. And that authority, it's in Webster and Page. It actually tells us, it's an old English case. It says that is why this confusion you see, that is why passing off that action is difficult and unsuitable for cases of a political nature. It's a case of kin. I'm gonna have to give to your lordship. Let me just. You will have to really bear with me. It's difficult to squash what I was to do in the time I have. I just can't. Anyway, what that case tells you, I'll get to it, because it's about when I reach passing off. But let me start with my first topic of the history, to the extent that in introducing passing off, my learned friend made an attempt to describe the history of umkhonto. And I do this briefly because there is no dispute about what it was. And no one can tell us that the ANC was not associated with MK, and no one can tell this court that the ANC was not to give political direction to alliance partners in umkhonto when it started. But of course, history gets lost, my lord, in the wicked wit of lawyers and politicians, and history disappears. It's true that the ANC has played a very dominant role in giving political direction in the struggle in the 60s. And if you periodize it, it's the only way you're going to understand this, is to periodize the history of the ANC, even starting before it was formed, to 1910, 1949, when it radicalized the youth, and 1955, when the Congress of Democrats and other parties come in, And then it leads you to 1961, because it's a different kind of radicalization of a decision by those alliance partners, not one, by all of them, to create an army. And it's not an army, if you look at the manifesto, it's the army of the people, founded on the basis that the settler colonial state at the time had become brutal and violent, and it sought to defend them. And my learned friend says, we've always known that the ANC controls the MK. Well, that's of no moment. Everyone who's involved was a South African knows that for each alliance there's a political leader, there's political leadership. And one of the distinguishing features of Umkhonto we Sizwe was two things. One, it was not a regular army. Two, it was preceded by a group of people, South Africans, they call them combatants drawn from the people, who would independently defend people in different places in order to defend, not the ANC, to defend the people and the struggle against the colonial, settler, racist state. And all of these parties were important. I'm saying that summary, and I'll say your lordship must look at the manifesto, because the ANC has quoted it and it's correct. Where my learned friend gets it wrong, he uses non-legal terms. It belongs. No one can deny that the ANC had a hand, and I think you'll find that in paragraph 33 of the replying affidavit of the ANC. It's correct. No one should stand in this course and deny what the ANC was in the struggle within its alliance partners that formed this. So to the extent that here was an army that was a guerrilla army to defend people, the second aspect of it was that it was an army that fought what they called, and it's in the manifesto and the code, a people's war. And it's for that reason, as I close, that my learned friend talks about the fact that at some point there were divisions about whether or not it was the right move. It's because this, you look at the manifesto of Umkhonto we Sizwe, you look at its oath, it tells you this was a calculated, noble move by a group of people, not in the ANC, but in the Alliance Congress, to support a struggle that was waged and led by the ANC. And in that way, that kind of political control, which is correct because it sought to give direction, so that all combatants fall within the political prescripts of a particular ideological line. It was correct, but it does not translate to exclusive ownership, which is what trademarks and passing off are about. Let me then move. We don't have time to know what MK was, because I think we all agree. If your lordship can look at paragraph 19.3 of the answering affidavit, you will see that what we're dealing with there is, I may be wrong about, but at paragraph, that paragraph states, I think it's 19.3 or 19.20. I'm gonna find it now, my lord. 117. It's the paragraph to which the ANC replies in paragraph 33. I just don't want to page around, but it's there. No, my lord, it's not this one. Can I come back to you? I'll give you the specific, but it's probably 19.17. I'll find it, but I'll tell you the gist of the two. One paragraph in the answering affidavit of Umkhonto we Sizwe says that this was not formed by one organization. It It was a multi-organizational endeavor. Yeah, no, it's fine. I'll come back to it. I don't think it's that one. In paragraph 33 of the ANC's answer, reply to that, is that they admit that this army was not formed by one organization. That's the point I'm making. And I'll find the reference for your lordship. I'm told it's paragraph 19.5. It says the ANC never enjoyed exclusive ownership. This is not in dispute. It's not in dispute. What you have is nuances that fail to understand political direction and ownership since this 1961 and later. And so what is being said by my learned friend, Mr. Marot, is not wrong, but it's actually a mistake of mischaracterizing a relationship between a party that gives political direction. And you'll find that with ISIS, you'll find it with Hamas, you'll find it with the PLO, and all armies of people that are occupied and oppressed take political direction from somewhere, and that does not mean ownership. It has never. All right, let me then move quickly to the second topic. So the point I'm making there is that there is no sign, no evidence that there was exclusive ownership. But in our heads, we've dealt with the principle of passing off. But let me just start with what Judge Harams says in a case that I think locates these kinds of disputes as disputes that must be seen within the prism of the Constitution. And once you are there, you must then decide whether you are dealing with trading in goods and services, which is of commercial value, or you're dealing with Section 19 political rights, which leads you to what my learned friend, Mr. Marot, correctly calls it the consumer, in his example, is the voter at the ballot, booth. That was his answer to your lordship about what is the confusion. He says it's the voter at the ballot booth. And he's right. No one who's honest can deny that this dispute, if it's a dispute, is about that. Now, if that is the case, then this dispute of passing off, this dispute about confusion, is located in Section 16 of the Electoral Act as a special, because it takes it to the Electoral Court as a specialized court. And so, what exactly is the ANC complaining about? Well, in paragraph 22 of its affidavit, the ANC says, given that we are in electoral environment, that tells you which category of rights we are in. Time is of the essence. Of course, they say this in the context of urgency, which they haven't addressed.
So you're reading
paragraph 22 of the founding affidavit of the ANC.
22.
Paragraph 22.
That's page 13.
It's page 13. It's fine, I've got it. Now, it may be said in the context of trying to justify that this matter is urgent, which we all know is not. But it tells you, coupled with my learned friend's answer to your lordship, it tells you that the environment that is at issue in these proceedings is the electoral environment. And therefore, it locates it. This is some kind of lack of right and wrong forum. This battle we're having today is in the wrong battlefield. It neither belongs in the electoral court because that's been decided, nor here if you want, because it's actually a battle for political mind share, which no court can determine. That's what it is. And that's why your lordship and my learned friends are battling to locate it. That debate you are having because this is not a battle for a court. It's a battle for political mind share, and it's a legitimate battle. It just happens to be in this court because South Africans have a tendency to come to court as an extension of political gains. But it shouldn't be, because it's a battle for mind share, which is legitimate between political parties. And so it says, deliberate acts, this is the paragraph, deliberate acts to cause voter confusion, erode free and fair elections. Now it tells you the realm in which we are operating, the domain in which we are operating. All you will see that you put aside the fact that this point, as I said, is made in urgency, in the improving agency. Trademark law deals with trade in goods and services. Strictly. It's in the area of commercial law. That's trade. That's why everyone is battling to tell you what they sell. What are the goods? What are the services? I hope it's not the people. There are no goods and services in this regard because it's in the domain that is placed elsewhere in the Constitution. And so this battle has to do consequently with the fact that this battle doesn't belong here. Now, of course, by its own version, the ANC, as I said we are in the realm of Section 16 of the Electoral Act. That's where we are if we are to go to any place. If the courts are a battlefield, it's not this court. And let me say, services is defined this way, to include offering for sale or the sale of goods in the retail or wholesale trade. That's the definition in the Act of services. So what exactly is the definition of passing off then? What is it that essentially tells your lordship what passing off is? Because we've been throwing this word around. And what is its definition? Well, the ANC claims in its founding affidavit that there are two elements. It's reputation. In the English law, they talk about goodwill. And they also say it's about misrepresentation. And they make this case in paragraph 90 to paragraph 109 of their founding affidavit. It's paragraph 90 to 109 of the founding affidavit. And at the heart of that claim is what it says. It says, since its inception, the ANC's Umkhonto weSizwe has been known as such and has never changed. It means belonging. In this regard, the ANC relies on various posters to make this point. And these posters of bearing the MK symbol, you will find them in the SSCP conference posters. You will find at a funeral of different people. So that takes us nowhere. But here is the punch that I think tells us and settles this question at least. Is the ANC's admission, the MK party says that the decision to establish Umkhonto weSizwe was not an organizational one. I think it's clearer in 19.10. And the ANC says, and I quote them, it's page 224 of the papers. It says, the applicant does not take issue with the historical context as narrated. That's the end of the dispute about the history. It should end there. That's their version. Can I cite a couple of cases that I think define this without reading the definition of passing off?
You're getting Goes to your channel.
I'm gonna end now. As I said, it's not the court's fault. The case, my lord, is this. It's Capital Estate and General Agencies, Pty Ltd.
Are those in your bundle?
It's not. I thought about it as the
Okay.
points were being made, but I'll give the full citation. It's not. Two cases are not in those because my learned friend was making points that I think are contradicted elsewhere, and I found these cases. The Capital Estate and General Agencies, Pty Ltd. Versus Holiday Inns Incorporated. It's 1977 to SA 916. A, it's the appellate division. Now, of course, my lord, we all know that passing off is an action designed to protect a business against misrepresentation.
What paragraph are you reading?
My lord?
What paragraph?
No, I'm saying this as a tried principle. That's what it is. But the court says this in the Rabbi J.A. then as he was then says, the wrong known as passing off consists in a representation by one person that his business or merchandise, as the case may be, is that of another, or that it is associated with that of another. And in order to determine whether a representation amounts to a passing off, one inquires whether there is a reasonable likelihood that members of the public may be confused into believing that the business of the one is or is connected with that of another. Close quote. It's as I said, it's 1977 to 916, or it's 918. Thank you. All right, there's another case which is this. I won't read this. It's an old case that is quoted in that one. It's Polanski Brothers, Ltd. versus L&H Polanski, 1935, AD 89, from pages 97 to 113. The definitions there tell you that we are in the realm in which the ANC, in its current case has pleaded, cannot locate itself within. What they have not done, he quoted two requirements. Said to your lordship, there must be reputation, which is true. There must be a misrepresentation. But of course, my lord, there must be damage to that. There must be damage or apprehension of damage. But how do you do that? You do that by providing sufficient evidence to demonstrate that damage has happened as a result of, let's call it the misrepresentation, or damage is apprehended. Now, my lord, here is a summary of this case. This is not a case of association. It's actually a case of dissociation from the ANC. There is absolutely no legitimacy in arguing that MK Party seeks to represent itself as the ANC. It wouldn't make sense. In fact, the opposite should be true. And therefore, if the opposite is true, the case of passing off falls flat. Because you must seek to be seen as the other for passing off to happen. Or you must seek your goods to be interpreted as sourced from the other. And that is the end of the passing off. My lord, just for you 1 minute left about the three elements of interdict, which no one has dealt with. The debate your lordship was having with my learned friend, Mr. Mpofu, about whether there has been a registration or whether there has been exclusive ownership is about a clear right. Not a prima facie right, a clear right.
The applicants are asking for final.
Yes.
The applicants are asking for a final.
Yes. They ask for a final interdict. It means it's not a right you must claim that you could guess that it's there. It must be a clear right. And your lordship was at pains to point out that there was no shred of evidence that could satisfy just that requirement. The second one is what I've just talked about, whether there is damage. And that, of course, coincides with the requirement of what a passing off must be for a party to complain about. That there has been, I have a reputation, and there has been a misrepresentation in order to damage my reputation, that, or goodwill, as they say in the English law. That is the nature of passing off. There is no evidence for damage caused or not caused. I don't believe there's an ANC member who will confuse Umkhonto Wesizwe Party with the ANC. It is not true that members of the ANC can be confused about the face of Cyril Ramaphosa on the ballot paper and that of whoever will be on the one for Umkhonto Wesizwe. It's actually a statement that is condescending in nature to the voter. And if that is true, the case for passing off doesn't work, and the second leg of the three requirements for an interim, for a final interdict. And we don't have to get to the other one. Even if they do have an alternative remedy of what they would do if they went to the right forum, the right battlefield, with the right arms. And I've said they did. Mm-hmm. They went to the commission with this very complaint. Mm-hmm. But in any event, as I said when I started, my lord, the battlefield for this is not here. It's actually people respecting Section 19, which allows everyone to compete for political space. It is just said that people are in this room fighting about political space that they now have, but don't want others to have. But generally, Section 19 was to make sure that we can exercise that political space and use every non-violent weapon we have to fight for political mind share. And that's where the battle is. And if parties could stop going to court and we fight about jurisdiction and compete where they must to persuade me that they have not forsaken us, they have not forsaken the people, all of them. No court has jurisdiction to deal with political mind share as a battlefield. And those are my submissions. I'm sorry if I took more. I think I took your 5 or 4 minutes.
30 minutes.
So I'm very sorry. It was difficult to do this. Thank you.
Thank you, my lord.